Sentencing and Parole Reform Bill. The question is that Clause 3 stand part. No, there is a purpose clause which takes precedent over Part 1. It's outside the Constitution. So you just stay with me here. Honourable Leanne Dalzell.
Mr Chairman, sorry, I hadn't appreciated that the purpose clause was dealt with first. The purpose of this Act, according to the purpose clause, is to deny parole to certain repeat offenders and to offenders guilty of the worst murders. And I think there's a problem with that language because it includes manslaughter as well. And it's an interesting juxtaposition that we've actually created in this legislation when the Minister, of course, will know that there are those people who are found guilty of manslaughter who couldn't possibly be defined as guilty of the worst murders. And I just want to mention a case that I became familiar with when we had the debate on provocation. And I just would like the House to reflect on the fact that this purpose clause refers to worst murder. Well, I think it's worth doing. I'm trying to be helpful and ensuring that the House is looking at all of these issues. But there was a couple who entered into a suicide pact, essentially, an elderly couple. Both were not very well. And unfortunately, in the suicide pact, I mean, the whole situation was unfortunate. The husband was successful in assisting his wife to complete suicide, but he wasn't successful in his own suicide. So he was charged with murder. He pleaded guilty, and he was sentenced under our new law, which doesn't require life imprisonment as a mandatory sentence. It has to be imposed unless there are good reasons not to, but it's essentially no longer a mandatory sentence. And one of the issues that came up in the course of that particular case was that the result essentially was that he was granted home detention. Now, you couldn't possibly describe him as having been in this category of an offender guilty of the worst murders when he'd pleaded guilty to murder on the basis of not having a trial. He wasn't very well himself, and I think there was a recognition from the Crown that they weren't going to prosecute for the life sentence that could have been given in that particular case. And if there hadn't been the alternative to life imprisonment for murder at the time, then that would have been a judge, I think, that would have found it very difficult. And I personally think that he probably would have pleaded not guilty if there hadn't been the alternative to life imprisonment. So the trouble is that the language of this says that this is what it's for, but it means that it's going to capture a whole lot of people that aren't in this category. So somebody, for example, who's had a youthful time going down the wrong track and committing two very serious offences when they're quite young, and then having a period of redemption, finding themselves, making up with those that they've offended against, and then restoring themselves onto a good path later on in life. If that was that gentleman, and he would then face the maximum term of imprisonment because he would be regarded as a persistent repeat offender even though he had only committed two serious offences at a time when he was young and not really fully grown and not able to make the right decisions at that time in his life. And I guess the purpose clause is trying to encapsulate what the government's trying to achieve. But I think what it fails to do is it fails to identify that there are always exceptions to these rules, and I don't know whether the exceptions are actually identified within the purpose as well. And also, as I understand it, the bill, and I'm not as familiar with this bill as others because I didn't sit on the select committee, but my understanding is that there are provisions that enable the application of parole to certain repeat offenders and to offenders guilty of the worst murders, because there is an alternative provision in there for those cases where it would be, and I can't remember the exact phrase that they use with respect to the parole, but there is an alternative if the judge determines that it would be a breach of, I just can't remember the exact wording of it. Somebody would help me out, I'm sure, if they could.
Yep. Yep, no more. Right.
Sorry about that.
Carmel Sebaloni.